for entertainment purposes only. And if you want true legal advice, contact your own lawyer.
So here's the answer, and I'm going to let Todd and Denise discuss this a little more. And this is kind of down Todd's, Denise and I. It's we understand this, but this is down his little road. There were apparently some personal notes from Rick Singer, the guy that masterminded this whole thing, that basically point to the FBI investigators directing him, this is according to Rick Singer's, this is according to Laughlin's lawyers, that directed him to lie and say that Lori Laughlin and others knew about this when they did not. Go ahead, Todd.
Yes, it's so a little bit of history on this. Back in December of last year, the defense for Lori Laughlin filed a motion in federal court asking the court to order the prosecution to turn over exculpatory evidence pursuant to a case that criminal law attorneys know called Brady versus Maryland. In that case, the Supreme Court said that the prosecution has an obligation to turn over to the defense any exculpatory information, whether the defense has asked for it or not, because oftentimes the prosecution will come across it and the defense has no idea it's even there. And obviously the prosecution is not going to want to put on evidence that a defendant is not guilty in their case in chief. So how does this ever come out? And they said, look, court said, you got to turn that over. So this motion was filed.
And you have to turn it over like within 30 days of discovering it, correct?
Yes, you have to turn it over pretty quickly. Sometimes under normal discovery, you don't have to turn it over until a certain number of days before trial. But with exculpatory evidence,
which means what?
Which means evidence that the defendant is not guilty or would reasonably lead to the discovery of evidence that the defendant is not guilty. That has to be turned over even before the preliminary hearing, which other discovery doesn't necessarily fall under that. So this motion was filed. I think it was argued either in late December, early January along in there. The judge ultimately ruled, yeah, the prosecution have to turn over any exculpatory evidence. And I suspect at this point that the defense had been made aware that there might be these notes out there that Singer had made, that his personal notes of the interviews that he had with law enforcement, and that those notes might shed some light on what his testimony what should have been when it was authentic versus what the government was pressuring him to say. So the judge said, you got to turn it over. And they did, and lo and behold, recently, when the defense got this evidence, the notes say, where Singer is saying, they want me to fib. They want me to say that these people...
the FBI.
The FBI want me to say that the defendants, Laughlin and others, knew it was a bribe when, in fact, they thought it was a donation to a charity.
The schools.
So they want me to say this, and that's in his notes. And so this has now come to light. And the defense, Laughlin, is now saying, hey, we need a continuance of the trial date so we can further investigate this. I don't know if they're going to get it or not, because the trial date's not till October. I think a judge can say, I'm not going to continue it right now. You do the best you can, then come back to me like in August or September, and we'll see if you need more time at that point. But
what's interesting is the notes were written to Singer's attorney.
Yes.
So these are notes that he took after he's interviewed by the FBI, and he's writing to his attorney and literally saying, quote, they further note that the government's desire is to nail one of the defendants at all costs. Close quotes.
At all costs.
At all costs.
And he's describing the phone conversations as being abusive, and the government is yelling at him. Now, let's address a couple of issues here, because you said these were notes to the attorney. And I think the first time the Laughlin defense sought these, there was this claim of attorney-client privilege on the part of Singer, that they were saying that Singer has attorney-client privilege, so the government, don't have to turn over these notes because they're covered under the privilege between Singer and his attorney. Okay, couple of issues with that. First, the government cannot claim attorney-client privilege on behalf of Singer.
Absolutely not.
Singer has to claim it.
That's correct.
2, the minute Singer and his attorney turned the notes over to the government, they waived the privilege as to those notes.
But I wanted to be the devil's advocate. It's possible that they got those notes through a search warrant. It's very possible that they actually got it, because the notes that were sent to them, it's not real clear if it's emails or if it's handwritten notes, or if it's a combination of emails and handwritten notes.
But let's remember this, okay? Singer hasn't been sentenced yet. Singer hasn't been prosecuted yet. Singer is cooperating with the government under the idea that he is going to get a more favorable sentence or favorable treatment by the government if he cooperates, right?
I don't like all that stuff.
So he is cooperating here. If it is shown by these notes that it blows up the case against Lori Laughlin, that still does not act as a defense for Singer. If everything goes away because of all of these notes against Laughlin, that leaves Singer as the only bad actor in all of this, with zero promise from the government for leniency. And so I could see why Singer might not want these notes coming out, because if the notes come out, my goose is cooked. Because regardless of what Laughlin or her husband or anybody else knew, if I was truly telling them that these things were donations and they were really bribes, I'm still on the hook for it.
Yeah, he'd still be guilty of it.
Exactly.
But it doesn't necessarily breach his agreement with the immunity portion of his agreement with the government. Or not immunity, but whatever they've got an agreement on, lesser sentencing or whatever.
If I was the government, I would say, well, I get that, but when we made this deal with you, why were you writing notes that made us look bad and giving them to your attorney that could later be used against us? They would say that him taking the notes down is, the problem here is it's all dirty pool. Okay,
right?
It is all dirty pool.
The government's an actor too.
When the government,
it's
actor. All dirty pool when the government has evidence of somebody's innocence, and they hide it. They don't turn it over. And look, these are all allegations.
These are allegations.
But if it was true that the FBI agents were pressuring him to say things that were not true because they wanted to nail the Laughlins and some big fish, that is absolutely wrong. And this is an area where the government actors, not just a government agency, but the individuals prosecuting the case and investigating, can face personal liability. And as I told you on the break, I refer you to one Mike Nifong, former district attorney in North Carolina, who held evidence back in that Duke lacrosse case where the exotic dancer claimed she was assaulted by the team members of the lacrosse team, and he suppressed evidence, suppressed DNA evidence, and it turned out that hadn't happened, and he had not given over the evidence. He was disbarred. He, lost the job. He was disbarred, sued by the families to the tune of $2 or $3 million, personal liability for messing around with discovery. That's where lawyers get in trouble.
Well, you know what? I really want Laughlin to get off on this and to get exonerated. You know why? Because I miss watching her on TV.
There you go.
I really miss it a
Hallmark
lot.
movies just
I love
the
her.
sappiness just isn't
That
the
was
same.
When Calls the Heart is my favorite
My wife
show.
loves that show.
Oh, Cal, go ahead. I got a couple comments on
I was just going
this.
to say, you know
before
what they
we end.
say: the bigger the bust, the bigger the boost, and the more the media, the bigger the bust.
Yeah.
That's just how it is.
I want to end this with. I want to end it with some quotes. FBI agents yelled at him. That told him that the clients who participated in the alleged side door scheme, that their payments were bribes. The government's don't forget, this is all in their motion. This is Laughlin's motion from their lawyers. The government's desire to nail one of the defendants, quote, at all costs. They were loud and abusive calls with the agents, with Singer. The other thing is, another quote is, the supplemental discovery produced today, and this is Lori Laughlin's lawyer arguing and putting it before the judge, demonstrates the government was simply not being truthful with defendants or the court in the above filings. This motion, and then it concludes saying the government is trying to benefit from withholding information in violation of the obligations, the defendant's constitutional rights, and that's why they wanted to force the trial as quickly as they can. And this is terrible. If this is true, it's allegations.
Yes.
This is horrible, ladies and gentlemen of the jury.
Go to the website, radiolawtalk.com. That's radiolawtalk.com.